Hello and welcome to Exhibit A. Today we have Mane, who's going to help us understand a complex military pension issue. You'll be educated as to how this has worked out in California courts. Stay tuned. Mane, how are you?
I'm good, Don. How are you?
Good. Thank you so much for joining us in discussing another case. You were so willing and so good at this that I probably rely too much on you to come in here and talk about these cases, but I think that they've been very educational. Today we're going to talk about a military retirement, and I think that this isn't going to be a very lengthy discussion, right? I think we could agree that it's not one of our more complicated cases, but it's not lacking of importance either, right?
No, it was definitely an interesting one. I think it touched on a couple smaller issues as well within the opinion.
Yeah. So I think that before we begin, let's just say that military people have a lot of sacrifice that they give, or they make a lot of sacrifices for all of us. Their service is usually pretty hard. I think we don't appreciate what they have to go through. They protect us all the time. David, can you play some national anthem or something? No, I'm just joking. But seriously, I served in the military, and I know what kind of sacrifices these people make. And one of the things that happens with them is when they are when they're stationed in various places, they have to adjust to the local environment. Let me give you an example. When I was in the military, after I came back from Korea, I was stationed at Fort Knox, Kentucky. And
Wow.
Here I am, a Chicagoan, right? And I'm in Kentucky, and it was a completely different type of environment. The little town outside was Radcliffe, right? And then there was E-Town, and they had the typical Southern, state troopers out there, and it was a different culture and stuff, and while you're there, you really have to get acclimated and learn that they have their way of doing things. Well, when people are married and they have kids and they move around the country, they have even a harder time, I think, in adjusting to where they're at. So this case that we're going to talk about is a divorce that occurs in California.
Mm-hmm.
Two people that are in the Navy, and I'll let you kind of set it up. But it's really interesting when you think about who they are. We read it in paper as far as what the decision says, but when we humanize the people in here, we understand, maybe where they're coming from.
Yeah, for sure. So, like I said, it was a pretty interesting read. Both of these, both the wife and the husband, they met at the Navy, and they're both attorneys, from what I understand. One of them was retired at the time of the separation. One wasn't. I forget which one.
So you just said something that I forgot about, that they were attorneys. So we call them JAG lawyers in the military, right. And so I forgot about that. So now there's going to be some litigation, right?
Right. I think the husband wasn't practicing. He was still, I think, serving in the Navy Reserves, and he also had his. Oh, I'm sorry. No, he was. He had his own practice, and then the wife was a Navy lawyer.
So she's still active in the Navy, full time, I presume, and she's lawyering. He, on the other hand, may be a reserve, but he's not. He's no longer. He's residing here, and he's got a private practice in
Correct.
California. Okay.
Yes.
And there's two children?
Two children. I assume there's no custody issues because that didn't really come up. Okay. But they were married in 2016. 2016, wife filed for divorce. And to initiate the divorce, we all know in California you need to fill out a form called the FL-100, and she checks some boxes on there.
And what is the FL-100?
The FL-100 is the petition for dissolution.
And it requires you to fill out details.
Right. You check off, your date of marriage, date of separation. You have to indicate the residency requirements for having to file in California, which is 6 months of the county and 3 months of the state, I think, or the other way around.
3 months county, 6 months
months
state.
Yeah. And then, she also has to fill out whether the court needs to be involved in dividing any property that the parties may have. Custody, what your preferred custody arrangement is, and what, if you're going to request support, spousal support, attorney's fees, and all of those issues kind of get addressed initially in your petition.
Right. And And I think it's important that you say she was the one that filed, and we'll talk about that later. This case might have been different if he had filed, and we could talk about that.
Yes, definitely.
And again, with the petition, what the petition serves is notice to the other side and to the court about what you think this lawsuit is going to be about, right?
Right.
So, you're duty bound to say, Judge and, soon-to-be ex-husband, when we start litigating this, I want the court to make orders pertaining to child custody, child support, spousal support, attorney's fees, and property division. And I'm putting it in the pleading so you're on notice. If I don't put it in there, then I don't get to ask. So I'm putting everything in here. And
Exactly.
that's how this case starts, because she files a petition asking for certain types of relief.
Exactly. And as you know, of importance here was in the property section, she asked for the court she used this specific language that all attorneys normally put on those forms is, at the time you file, you might not know everything that's out there, you might not list everything as far as property, but you put this general statement that you want all property, acquired prior to the marriage or after separation to go to you, and then you want the court to determine division of all the community property assets that might exist.
And I put the quote in my notes here is, confirm as her separate property all property acquired prior to the date of marriage. The nature and extent of community and quasi-community assets and debts are unknown to her and at this time to be determined at the proceedings. So like you said, it's kind of some boilerplate language like that.
Yep. And she did list some specific real properties, which, you always want to list any real properties that you know of at the time, because that's beyond the scope of this podcast, but that gives the court jurisdiction to make orders about the properties, and you can file list pendants. But yeah, I won't get into that.
But here's part that we should probably cover is that she lists 4 real estate properties in a sailboat. She leaves out any reference to her military pension, but adds petitioner desires the parties to reach a full agreement on all issues.
Yep, exactly. So she files, he responds, and they both seek spousal support from each other.
Okay, so before we go any further, I think that we've got to address domicile.
Yes.
Okay, so how does that play out in this case?
So she, by filing in California, I'm not sure if the court specified where she was.
She's domiciled in New Jersey. This is a woman that comes from New Jersey.
Okay.
And she's been stationed in California.
San Diego, I think.
And I assume her husband is a Californian, or maybe he wants to be.
He was practicing there, remember?
Yeah, but she's not from California. She's from New Jersey. And that's going to play out in this case, because she's going to claim that, hey, I'm domiciled in New Jersey. And I don't think that's even in dispute as to where she was. But she could file here because the parties were residents in the state of California and the county for the period of time that you talked about.
Right. Like you said, it might have played out differently if he was the one who filed.
Yeah.
Right. After the petition is filed, like I said, they request spousal support from each other, and then they try to attend a private mediation, which is unsuccessful. And at the mediation, this issue comes up of her military pension.
Right. And husband makes a specific request during mediation. He wants to exercise his quote-unquote Gilmore election. Could you describe what that is?
Yeah, briefly, I'll just overview of what that means is whenever there's a military pension that needs to be divided, the non-employee spouse may make an election to receive the benefits prior to the employee spouse actually retiring from the military in order to start receiving the benefits.
Yeah. So let's use this as an example, and we'll take it out of the military because we're talking about California law. We're not talking about federal law here. This is specifically California. Let's say that you have a county employee that's been working for 20 years, and they've been married for 20 years, and on the 20th year, she files for divorce. He's capable, under this hypothetical, of retiring right now. But he says, you know what, I'm not. I'm going to keep working. So she has an option. It's a Gilmore election. She could say, I want to get paid out right now, So I'm not going to wait until you retire, because
Right.
who knows, you're the type of guy that's going to retire, you work until you're 100 years old. I'm not waiting. I want my money now,
Right.
right?
The
And-
community share, she can
Right.
start earning that.
Right, and we won't get into how that's done in this podcast, but she can make that request. Well, in this case, it's the shoe is on the other foot. The husband's asking for a Gilmore election because she's still working. He says, I want my money now.
Right. He wants his interest in her military benefits right away. And the wife rejected this and said no, that you're not entitled to a Gilmore election. And I'm not sure.
She's saying that California doesn't have jurisdiction.
Right. I think that was her main argument, that you're not entitled to, you can't make that because California doesn't have jurisdiction over to divide the military pension. After she makes this argument, she files a request with the family court asking for a 730 expert to be appointed. And what that means is she wants an expert to be appointed to determine division of property and other issues related to spousal support, such as income and how the property and retirement accounts are going to be divided. And I highlighted something important that she put in her documents.
She's saying that the federal law, which preempts state law, has the rules concerning military retirements. And she's saying
Yes.
that I did not consent to California having jurisdiction, and it cannot be implied, because you don't see it anywhere as far as explicitly saying, I consent, right?
Right. And I forget the full name. It's the Federal Uniformed Services Former Spouse Protection Act.
Yeah.
And she says that because of that's in place, then the court can't make any rulings about the military pension, 'cause she never expressly consented to that for the court to have jurisdiction. But in her paperwork, when she filed a request for the expert to be appointed, she asserted that the community and separate interests in those accounts must be determined to permit us to equitably divide the community estate. So that's important as well, and we'll get to that later.
Okay. And of course, the husband disagrees with her, and they go to trial. And
Right.
the trial court makes some rulings.
He actually filed, he disagreed on the Gilmore issue, and he filed a request for order seeking immediate division and payment of her military pension. And like you said, the wife objected to that pursuant to what it
Why
is.
don't we call it the federal statute? Because
Yeah,
it's
pursuant to it.
FUSFSPA. Try to pronounce that. FUSPA.
Right. Exactly. And then I think at this point is when she realized that, hey, maybe she shouldn't have filed that petition, because she also filed a separate motion for leave to amend her petition for the marital dissolution that we initially touched upon.
Okay. So this case deals with the trial court's ruling with regard to husband's request for a Gilmore election. How's the trial court rule, and why?
With regards to the request for order for the Gilmore, the trial court agrees with the wife and says there was no express consent from the wife that she gave jurisdiction to me to divide the pension. So I can't divide it, and the judge denies the husband's request for the Gilmore election.
Okay, so the husband loses at the trial court level.
Yes, he loses, and he tries to appeal this.
But before you go there, the court did reserve jurisdiction to order child support and spousal support retroactively, and it was because husband had said, I'm going to appeal this, and the court says, well, I'm going to reserve on those issues then, because that will impact
The
how
income.
much support will be paid and things of that nature.
Exactly,
Right?
yes.
Okay.
So he tries to appeal this, but it turns out that's not an appealable order, because it's not a final order, and he was unable to appeal the finding of the Gilmore election. So I thought the parties did something very interesting. They agreed.
I'm surprised that she did. Yeah.
Right, she agreed. So what they ended up doing was, once the husband found out he couldn't object this decision of the trial court on the Gilmore election, the parties then enter into a stipulated judgment, where it expressly reserves the issues of child and spousal support pending appeal of this Gilmore election issue.
So I don't know why the wife did that, other than the fact that she wanted some resolution or something.
I think that must have been it. Yeah.
Because the trial court's saying, look, I can't really order support here. until I get a ruling as to whether he's going to have this trickle of income from the pension, which would alter, both child and spousal support. So I guess what she's saying is look, I want some resolution here because I could be paying a lot of support.
I wonder if she could have just pushed forward to a trial with the trial court.
But then what was the court faced with? I mean, it's kind of interesting to the extent that I don't know who's got more custody or anything. We just don't know how much the husband's earning and stuff like that. But the fact that they agreed to treat this as a request for a writ of mandate, I think we'll never know the answer, I guess. So
Right. So what they ended up doing was they stipulated to a judgment. They attached it, they filed it, because they hoped that this judgment would be an appealable order pursuant to the Code of Civil Procedure. But it actually turns out that stipulated judgments are not directly appealable if they still reserve issues for later determination. So it turns out that the stipulated judgment actually was also not appealable. But then that's when they agreed to treat it as a writ of mandate, like you just said.
Good lesson.
Yeah, so I thought that was one of the smaller things, because I had forgotten about that.
Mm-hmm.
So then finally it's up on appeal, not as an appeal, but it's in front of the Court of Appeals because it's treated as a writ of mandate pursuant to their agreement.
Okay, so what's a writ of mandate for the non-lawyers out there?
It's another way for you to immediately appeal a lower court's decision whenever it's not considered a final order. So you ask for the Court of Appeals to review the decision. The process is a little different than filing a regular appeal, and because regular appeals have specific requirements, it needs to be a final order. There's a list of things that you can appeal. One way to get around that is to file a writ of mandate. It's not easy to get, but you can,
So writs of mandates happen usually during the pendency of litigation. Mm-hmm. Somebody gets an adverse ruling, and they're like, we need to get the appellate court's help on this. Mm-hmm. Not all issues have the availability of a writ of mandate. I mean, they're kind of select.
Right.
But what it is it's the Court of Appeals saying, trial court, I'm ordering, and that's where the mandate comes in, and the writ, I'm ordering you to rule a certain way because you got it wrong in the law. So that's what they're agreeing, hey, could you speak to the trial court and let the trial court know whether they were correct or wrong on this?
Right. I wonder if they hadn't agreed to that, if the Court of Appeals would have even...
Probably not, right? Well,
Yeah,
actually, it said
maybe.
it said it could treat it as one anyways, right? Because it said that not all issues were resolved, and therefore it was maybe okay for a writ of mandate.
Yeah, I think so. So then finally, this issue of the Gilmore election is up on appeal, and we then get to the Court of Appeals decision as to why the trial court was actually wrong about the wife consenting to the trial court's jurisdiction over her military pension.
Can you go through some of the reasoning of the appellate court?
Yes, absolutely. So the Court of Appeals, like I said, disagreed with the wife and disagreed with the trial court when the trial court held that you needed specific and express consent from the wife. So the court kind of went through some legislative history and looked behind the intent of why that statute was enacted in the first place. And it, gave a broad overview that the military pensions can only be divided if the employee gives consent to this, and then it discusses what are the three ways that the military service member would allow this to happen. So the first one is the residence of the military member is within the territory of the court. The domicile is in the territory of the court, and then it says consent to the jurisdiction of the court. So
Okay.
all it says is consent. There's no specific, reference to expressed or implied or anything like that.
Right. So what we know is that, and this is why I wanted to start off the way that I did, talking about the sacrifices that service men and women make. You could very likely wind up in a jurisdiction that's completely different than what you're accustomed to.
Mm-hmm.
You're from Wisconsin and you find yourself in New York and you're dealing with New York laws, or California versus Florida or whatever. Some places that the cultural differences are there and the laws are different. And so what I think that happens is that the federal government tries to protect our service people. They're like, look, we're going to give some protections here and there's some rules with respect to how military pensions are going to be divided, right? And how the court's going to have jurisdiction over that issue, because you could be like transferred for a 20, 30-year career from state to state to state, and it could be wicked with respect to dealing with the various courts. So they're saying that in order for any jurisdiction to have jurisdiction over the military retirement plan, there's got to be some elements that are met. Could you go through those again a little bit slower, please?
Yes, of course. So the federal statute says that a state court may not exercise the power to divide a military pension unless the court has jurisdiction over the service member by reason of, the first one is his residence other than because of military assignment. So that's very important. It can't be just because you've been assigned there.
Right.
It has to be your actual residence. The second way is his domicile in the territorial jurisdiction of the court. And then the final way would be his or her consent to the jurisdiction of the court.
So in a lot of cases, a military person has the control over that. In this case, the wife really had control because she's from New Jersey. She could say, look, I don't consent to this here. This it's actually 10 U.S.C. section 1408 C4C is the relevant code that you've been referring to, and it just deals with whether a state court has jurisdiction over military pensions. And so in this case, the wife could have said, Judge, I'm not going to ask the court to divide this, and I'm going to put the onus on you to try to show that I'm a residence or a domicile, which you can't because I'm from New Jersey.
Exactly. And of importance is that minimum contacts theory that we learn about when we, in law school about jurisdiction, that
it does
not apply here. It's not on the list. It's because the legislator, Congress, wanted to avoid people trying to forum shop and, go somewhere with more favorable laws and things like that.
So how does the court wind its way through the law here and come up with a conclusion it did? The Court of Appeal, of course, I'm talking about.
Right. So the Court of Appeals really references a couple of things that the wife did in finding that she consented to the jurisdiction of the trial court.
Can I stop you there for 1 second? One of the things that this court did that you'll see in a lot of appellate court decisions is it'll look at other state law decisions concerning the same issue. And this Court of Appeal noted that the issue of whether consent can be expressed or implied has been bantered around the country, and there's different decisions depending on what state you're in.
Right.
One state might say there can be no implied, others are expressed. California doesn't have jurisdiction over those other states, but what it does is it takes on the best reasoned one, right? It kind of uses its own logic, and it says what?
Right. It says, like you said, it goes through a couple of decisions that differ, and then says we're going to actually not follow those because we don't have to.
Right. And there's some states that have said that express is okay, and we like that. There's a better reasoned approach, right?
So the court discusses how the wife gave implied consent, and it goes through some of the things that she did. And we'll go back to the first item that we discussed was choosing the particular forum in which she filed. Filing her petition of dissolution in California was one of the factors the court looked at in determining that the wife did in fact give implied consent by participating in the proceedings, by filing that dissolution in California. The other item that the court looked at was the fact that she listed, like we talked about in the very beginning, she listed, division of property in there and said that I'll agree to, I forget what it was, the fair division, or I want to settle all the issues or mediate all the issues of property division, right?
So she says, Lisa specifically asked the court to confirm as her separate property all property acquired prior to the date of marriage. And that necessarily included the portion of her military retirement, is what the court said, yeah.
Exactly, yeah. I have that highlighted too. And then I think the fact that she had filed that request for that Evidence Code 730 expert as well, asking to divide all of the retirement accounts, was a pretty big factor that the court looked at in saying that she gave implied consent.
Big factor and possibly a big blunder on her part.
Yeah,
right?
it doesn't... I'm pretty sure both of the parties were represented by attorneys throughout the proceedings.
Yeah, I mean, I assume that she's that, but really interesting case. So she loses on appeal. The husband is entitled to his Gilmore election.
Yes.
Pay me now.
The trial court is given specific instructions to determine that, and again, like the way that Gilmore is done, they said the trial court does that in any way it sees fit, and then after that, then you can order child and spousal support, and then obviously would have final orders on those issues.
Okay, so the bottom line is the husband won. He's going to get paid out the half of the community portion of the retirement of a Navy officer who hasn't retired yet. And again, we're not going to get into how that's done. That's a different podcast. But I think that we need to focus on what this case really means. We know now that the court can look at implicit consent, right? Because when you're dealing with military retirements, I mean, we're all afraid of them, right? Because you got this federal preemption statute. And I think we purposely don't look too close at these things because they're kind of scary. I mean, the federal government dictates what goes on. Now we know that, state court can have jurisdiction over a military pension. The person can be from a different location, but there has to be consent, either express or implied, right? And so knowing that, let's assume that you're representing wife, and she comes into you before the divorce starts, and she says, look, I want a divorce here in California because I like the way that the laws are, custody, I want custody to be here and all that. If there's any problems, I want to be able to go directly to the court. I don't want to have to fly out someplace else. And I think, quite frankly, that California has jurisdiction, home state jurisdiction of the kids, so it's got to be here. But I don't want anybody touching my pension here. I want it in Jersey because Jersey, I think, is going to be more reasonable. It's not a community property state. I mean, I don't know, if there's any advantages or disadvantages, but I don't want it here in California. So where are you going to tell that client?
Well, I think the biggest thing here was the court said by choosing to file in California, she was giving the court jurisdiction. So I think if you could still probably file here, but include very specific language in the petition about why this filing shouldn't be considered as consent. You're not consenting to the court's power and jurisdiction over the military pension, and maybe even cite some of the cases that favor your position. And I think I would still probably advise the client that there's still a slight chance that the trial court might rely on this very case and saying, that's too bad because you chose to file here, so I have jurisdiction over the military pension.
Yeah. The way that I read it, I think that the mere filing here is probably not
No, I think that alone
factor. Yeah.
Right.
But you're right. You're kind of playing with fire a little bit, right? It depends on the judge.
A little bit, because I think you can put whatever you want in the paperwork, but
yeah. So I guess she could have. Let's say that she comes in and she says, "Mane, all I care about are the kids. I want primary custody. Do I have to file a divorce in order to get those type of orders? Because we're separating. That's how I feel. Because we know that you could file a petition for custody without having to do a divorce. You could even ask for a spousal support without going for a divorce and child support. So, she chose to engage the jurisdiction of the court. And like I said, you start playing with fire. So I think that if you're going to play with fire, be really, really careful with regard to what you're asking the court to do with regard to property.
Right.
Maybe explicitly put in the petition, I am not asking the court to make rulings with regard, and don't engage the services of an expert or anything like that, right?
Yeah, but like you said, I think probably the best way would be to just ask for custody orders and nothing else, not even file for a dissolution.
Yeah. Just a long conversation with your client as they come in about what are your goals here. You need to know about the ramifications of certain decisions that you make before we even start.
Exactly.
Yeah, cool. All right. So, we don't get a ton of military cases here. We do get some, but I think that California having as many military installations and people that are here, it's definitely here, and there's a reason for that. We're on the coast. You got the Navy, you got the Army, the Air Force is here. And when you get people that have to have these life decisions made, it's good that we're prepared for that.
I agree.
Okay. Well, thank you very much. It was a simple case, but it was kind of complicated at the same time.
Not so simple, I know.
Yeah. Okay.
Thank you, Don.
Thank you. And thank you for joining Exhibit A. We'll see you next time.